This is a petition for termination of parental rights and adoption. And Mr. Patrick, you have filed a motion to dismiss the petition of termination of parental rights and for adoption. So
That's correct, Your Honor.
apparently we are ready to hear that. Ms. Duke, you represent the moving party? Not the moving party, I mean, you represent the plaintiffs, right? Okay. Patrick?
Your Honor, we maintain that the petitioner's petition fails to meet certain statutory provisions, namely TCA 36-1-113-3A, which states in part as follows.
Pull that microphone down a little bit so we make sure we pick up on it.
Is this any better, Judge?
That's better.
All right. The Tennessee Putative Father Registry, it states that it must be consulted prior to filing of the petition or will be consulted within 10 working days thereafter. And there's one provision exception, unless the biological father has been identified through DNA testing, as described in 24/7/112. There was no DNA testing in this case for either party.
But this is the result, these parties were married and divorced, correct?
No.
They were not? Okay.
They were not, Judge, as paternity was
I'm
established.
sorry. Obviously, I looked at the wrong file.
No, Judge, no marriage. The child was legitimated through a default order in juvenile court in Dixon Juvenile. No DNA testing was consulted, and the Putative Father Registry had to be consulted prior to filing or within 10 days and immediately provided to the court. We have not seen any proof of that, Judge. And adoptions, as the court's well aware, be very technical for a reason. Well, not just adoptions, but termination of rights. And we have in the response and the petitioner's petition for both termination and adoption. And the consequences of not following the statute can have severe ramifications in the legal system and, of course, for the child involved. And we maintain that if they have failed to do so, this needs to be dismissed. Further, Judge, we maintain a lack of ripeness in this. Parties were married on December 11th, 2024. They filed their petition for termination and adoption a week later on December 17th. Generally speaking, the court has expected a 6-month period or a year to allow a stepchild and a step-parent to bond in daily caregiver and parental roles and for the marriage to season. Obviously, in a week's time, that didn't have time to occur. Additionally, the parenting plan in this matter was a default against the father. Mother herself requested, the petitioners requested that the proposed parenting plan include a provision, and it did, that neither party should have a romantic or sexual relationship around the minor child. We'd maintain if they've been married a week that either you're in violation of the parenting plan you requested, or there's been no time for said bonding. And once again, asked to dismiss. Further, Judge, lastly, I maintain that petitioners are appearing before the court with unclean hands. They blocked father from all communication with the child, all visitation with the child, and not at all abiding by the parental Bill of Rights. They knew that the respondent, Mr. Neely, entered residential drug rehab on or about December 2nd, 2024. The petitioners could have married at any time, but it appeared they tried to create a situation where the respondent could have no contact with his child prior, got into a quickie marriage 6 days before filing, and then still prevented him from having contact and precluded him from paying child support in the way he had been, cut off any access, text messages to the mother, anything. But, Your Honor, we believe for the following reasons this should be dismissed and attorney fees awarded to father on this. Thank you, Your Honor.
Ms. Duke?
Respectfully, Judge, the motion for defense is not, motion to dismiss, I'm sorry, is not properly before this court. I'll start with the first allegation in that it's alleged that the petition fails to meet statutory provisions regarding the putative father registry. I'd submit to the court that if Your Honor will turn in the file to December the 23rd, 2024, the putative father registry was registered with this court, and the acknowledgement from the putative father registry was filed with this court on December the 23rd, 2024, and Mr. Dylan Scott Neely was served at his last known address. Regarding the lack of ripeness, counsel for the respondent says himself that the statutes don't set forth a length of marriage requirement. They don't, so that's not applicable. It's a creative argument, but it's not applicable here. Regarding unclean hands, the parties have historically communicated through Miss Crosby's father, and I think that the evidence at trial will ferret that out. And so his lack of candor with the court saying that she had blocked him is not accurate. She had not blocked him. He always communicated through her father. So that being said, the court still has to take into consideration that there are other arguments in this file. The fact that he had a drug dependency problem, the fact that he had not fixed the drug dependency problem as of the date of the filing of this petition, the fact that he wasn't paying child support, the fact that he was earning a living through Miss Crosby's father's business, but was not using any of that money to pay child support. There are things that this court has to hear, and now that the court is aware that it's contested, I would ask that the court, number one, deny the motion to dismiss, and number two, appoint a guardian ad litem in this case.
All right, Mr. Patrick, you have the final say on your motion.
Thank you, Your Honor. I agree with Ms. Duke on the appointment of a guardian. I'd suggest, I can't think of the proper name, but Coffinberry. Vicky Smith, either one is fine with me, Judge.
Well, if I grant your motion to dismiss, I'm not appointing a guardian ad litem.
and
it seems to me that you are conceding that perhaps I'm not going to grant your motion to dismiss.
I'm going to cede to the wisdom of the court, but in arguendo, if
Maybe
you do
you
not
have
dismiss.
practiced in front of me long enough that you can read my mind.
I think I can, Judge. I will say, however, as far as communication with the mother, indeed there was some through the grandfather, but child support and payments and communications were done via text messages with the mother. The payments were done through Venmo. Both sources have been cut off. But at any rate, we respectfully request the motion be granted, and I defer to the wisdom of the court.
All right, well, the motion to dismiss states as its grounds, number one, that the petition fails to meet certain statutory provisions, and Ms. Duke has pointed out the statute that was cited requires that it be included in the petition that the putative father registry was consulted within 10 days prior to the filing, or if it has been identified through DNA testing, that it would be set out in the petition a copy of the response. In any event, within 10 days of the filing of that petition, there was a notice of consulting of the putative father registry. So that grounds, in this court's opinion, is not a valid basis upon which the court could dismiss the action. Secondly, the lack of ripeness is not a legal argument that under Rule 12, a motion to dismiss that I believe is appropriate. That is an argument that goes more to the court's finding regarding the grounds for the termination and whether or not that termination has been proven. And secondly, whether the termination of parental rights is in the best interest of the minor children. or child, because that is a two-step process that the law requires. Court has to first determine, is there a statutory meeting of the grounds for termination of parental rights? And then secondly, even if that has been proven, if it has not been proven, then it stops right there. But if it has been proven, the second step is to determine whether or not the termination of parental rights is actually in the best interest of the minor child or children. So those arguments that are made regarding the lack of ripeness and so forth and unclean hands, those arguments are not a basis upon which the court can dismiss the petition or would dismiss the petition. Rather, they would be arguments to be made at the final hearing. So the motion to dismiss is respectfully denied. Court will appoint Coffinberry as the guardian ad litem, since that was suggested. All right. Well, let's just avoid that and appoint Ms. Okay, well then let's go ahead and we'll appoint Ms. Coffinberry, but we'll give her an opportunity. If she finds she has a conflict for any reason, if she'll get with me, we'll find someone else. All right, call the next case.